Namaste and welcome to part 3. In part 1, we dealt with neutral evaluation and lok adalat. In part 2, we dealt with arbitration and conciliation. Now in this part, we will deal with the remaining alternative. Mediation. Yes, mediation is one of the most popular alternative dispute redressal mechanism. It is recognized under Section 89 CPC. Mediation has its own principles which are special to mediation. The parties are free to walk out of mediation at any time. That is to say, they have the right to withdraw from mediation at any time. Just because they agree to participate in mediation doesn't mean that they have to continue and have to compulsorily find a solution. They can always walk out of the mediation at any time. It's an informal process. It is not a formal process like a court process. There is a lot of flexibility available in mediation. Parties, like in conciliation, can agree to disagree, agree to partly agree to partly disagree. All is possible in mediation. Mediator is one who is a neutral third party who has no interest in the case or is connected with the parties or related to the parties. There are many more things in mediation which is making it one of the best and most popular mechanism. In one word, I would say it's a litigant-friendly process, and that's how mediation has become very effective and is resolving many disputes between the parties. Now, how to approach mediation? There are mediation centers in each district, each taluka level, which is set up by the Honorable High Court of Karnataka. The mediation for which you need the High Court mediation center to take up your matter shall be only by filing necessary application or a memo before the court and seeking the permission and then getting the matter referred to mediation. Once the matter goes before mediation, we have 60 days time, and it could also be extended by another 30 days. Mediation centers are there all over India. Privately also you can go for mediation. In such cases, you need not have to take the permission of the court for reference. You and your opponent can agree and go before a man whom you think that is capable of resolving the dispute between the two of you. There are many certified mediators whom could be approached. That's a private mediation. There are private institutions also which are doing a lot of mediation. They also facilitate mediation, and that could be an appropriate forum. The solutions, if it is through the court mediation centers, it will be sent back to the court with the settlement proposal of the parties, and the court will look at it, and if it is acceptable, it will accept it, and it will become a decree of the court. If it is by a private institution or an individual mediator, if there is a settlement, such settlement will be signed by both the parties, and it has to be under Order 23, Rule 3 CPC, and both parties have to present it before the court, and the matter will be taken up by the court. It will examine the settlement, and it will pass a decree if it is within the four corners of law. Now, the cases which are suited for mediation. All civil disputes are suited for mediation. It could be civil suits, matrimonial disputes, disputes pertaining to commercial matters, trust, partnership, recovery, declaration, appeals, that is to say first appeal, second appeals, revision matters. All matters can be easily resolved in mediation. If you resolve the matter in mediation amicably, you also get the refund of fee, that is to say the court fee, to the extent of 75%. This is also one of the advantages of mediation. In short, mediation, you can achieve peace which could be much more than the justice which you are going to get. Alternative dispute resolution mechanism has its own benefits. It reduces the pendency in courts. Litigations attain finality. Litigants move on in life. It restores confidence in judiciary. The litigant feels proud of his advocate. We have to recall the recent statement made by the Prime Minister of India, where he says that on one side we have to fight COVID-19 virus situation, and on the other side we have to also see that the economy revives. I feel that every litigation which is pending is causing economic recession in a way. For example, a immovable property between two brothers, there being a claim asking for partition. A suit for partition is pending in the court. Because of this suit and the pendency of the case, the property also suffers. There won't be any maintenance or development on the immobile property. The parties also suffer because they cannot enjoy the benefit of the immobile property. The legal heirs also suffer because of the delay in disposal of the cases. Whereas if we arrive at a settlement in such a suit for partition, where the brothers agree and resolve to enjoy the property in a particular way, the beneficiaries are the immobile property, where development will take place. The brothers also have a certainty and they also improve the property. The remaining stakeholders like banks, professionals, construction industry also benefit because of the development cost on the immobile property. I can also give another example. A contract work for road construction, where there is a dispute between the owner, namely the employee, and the contractor, resulting to the construction of road work being stopped. Because of the stoppage of the work, the entire road industry suffers, the public at large also suffer, and once the dispute is resolved and the contractor is able to continue the work and complete it in the given time, the entire area develops, commercial activities pick up, business activity will pick up, and traffic flow also will improve. In other words, every litigation results to a recession in a way, and disposal of a litigation, a finality to a litigation, results in economic revival too. So as advocates, we are also responsible for economic revival. Now let us understand the scope of the different mechanisms. Once a matter is referred to arbitration, the procedures contemplated in the Arbitration and Conciliation Act will be followed, and the dispute attains a finality by the award being passed by the arbitrator. It does not come back to the court at any time. The arbitrator also can attempt for conciliation or mediation between the parties, and a consent award can be also passed by the arbitrator. Coming to conciliation, If the matter is referred to conciliation and it is settled, it attains finality. It will not come back to the court. If it is not settled, it returns to the court again. Similarly is Lok Adalat, where if it is settled, it attains finality, and if it is not settled, it will return to the court. In mediation, if it is settled, it attains finality, but it is subject to acceptance of the settlement by the court. In other words, after the settlement is drawn between the two parties, the matter will be posted back to the court, where the court will go through the memorandum of settlement and it will accept it subject to it being in order. Switching from one mechanism to another mechanism is also possible. Of course, it is only by consent of both the parties. Mediation, as a mediator, has certain constraints, which probably is an advantage in conciliation principles. If the matter is not resolved in mediation, there is no prejudice for the parties to try for conciliation in such matters. Vice versa also is possible. By switching, it may sometimes result in more effective and more creative solution. I remember an instance where in one mediation, there were three major issues between the parties. One issue was core, and because of that, the other two issues could not be resolved. Now, the normal course was to terminate the proceedings because parties were not able to reach at a consensus. They were very rigid on their stand. Instead, both the parties agreed to refer that core issue to an arbitrator, submit themselves to the jurisdiction of the arbitrator, and call upon the arbitrator to give an adjudication. It worked. The core issue was adjudicated upon, and depending on that adjudication, both parties came back to mediation and they resolved the other two related issues. That reminds me, during the course of hearing the first appeal or the second appeal, if the court is inclined to remand the matter for fresh disposal or fresh adjudication, instead of it being referred to the court again, the civil court again, the parties by consent can always opt for arbitration and appoint the arbitrator and request the court to send it to arbitration for adjudication by the arbitrator. This is also possible. Section 89 CPC has been introduced 18 years back. Judges and juries have given different interpretation of this section. If I have understood it rightly, the Parliament is suggesting through Section 89 that there are few alternatives which are available to you. Please, you find a suitable alternative for your dispute, recognize a dispute resolution manager, approach him, take a solution from him, and if you are satisfied, be happy with it. If you have any difficulty, then only approach the court. Don't rush to the court for everything. In other words, the parliamentarians have tried to outsource the work of the judiciary to the alternative mechanisms. We have heard the Union Law Minister speak a few days back, as also the Chief Justice, about the digitalization and virtual court system. They are gaining momentum and it's going to be a reality shortly. We will welcome it. Friends, we have had the shortage of judges. Now we have enough judges, but there are no courts at all. By the time we get used to the virtual court system and accept it and adopt to it, it will be nearly another 12 months. Some cases and clients cannot wait so long. they require quicker and immediate justice and relief. I have a suggestion to make. Identify some cases from your case file register in your chamber which according to you require immediate justice or solution. Contact your party and take him into confidence. Contact the opposite side also and explain the process, how we can try alternative mechanism. Merely because you have agreed to go for alternative mechanism doesn't mean that you are agreeing for the solution too, or that your case is weak. If you refer 3 cases per month from today, for the next 12 months, it will be 35 cases in the next 1 year. And if you get 40% results out of that, that will be a very big achievement. In our own interest, it is time for us to have an open mind on ADR, take them seriously. Let us make the ADR work. Let us take the ADR forward. Let us be the catalyst of change and the ambassadors of ADR and try to revive the economy. COVID-19 leads to era of alternatives. Thank you.